Welcome to the Trial Bible, where we break down the secrets of courtroom victories with the best trial attorneys across the country. Each episode will sit down to explore their recent winning verdicts, the key pattern jury instruction charge that made the difference, and the tools they use to hit big. Let's go. Welcome back to Trial Bible, where we break down real trials verse by verse, strategy by strategy. Today, we are heading west, way west into tractor country. Our guest is Ross Pesek, a trial lawyer from Omaha, Nebraska, who just tried a case involving a propane explosion, a disabled immigrant plaintiff, a beloved Nebraska farmer, and a corporation that tried to sell a jury on the idea that a massive fireball was safe. Ross didn't just win the case, he sequenced it, protected the farmer, exposed corporate doublespeak, and let the jury do what juries do best when you give them the truth. Ross, welcome to Trial Bible. How are you?
I'm doing great. Thank you for having me.
It's my pleasure to have you on. I'm so excited to talk about this one, specifically because of the jurisdiction that we're in. You know, we've been hearing from New York attorneys. We've been hearing from attorneys from California. You are our first Nebraska attorney here. Tell us a little bit about the jurisdiction, the county that you were in before we even get to the facts of it.
Well, Nebraska is interesting. I don't think a lot of people really know too much about it. So, when you say I'm from Omaha, Nebraska, if you're from New York, it sounds like I'm way west. I'm a hayseed, right? But if you're in Nebraska, Omaha is me being a city slicker. And so Omaha is about 1 million people. And, without getting too much into it, it really is the last frontier of the East. Once you go west is when you start getting into, vast expanses of open prairie, then you get to the mountains, and of course you get west of that even, and you get California and all that business. So Omaha is like the last big city, and that's where I am. And I'm even from honestly the most urban part of Nebraska. For anybody out there speaks Spanish, the high school that's right next to us is 86% Spanish speakers, and I'm bilingual in Spanish. Our whole firm is 100% bilingual.
Wow.
But we end up all over the prairie. And I kind of take the approach that we'll go and we'll take a case anywhere. Forgive me if that makes me sound like a competitive type of guy or whatever, but anywhere that anybody wants to have a trial, we'll be there. This particular case was about 2.5 hours west of Omaha in what's called Buffalo County, Kearney, Nebraska. They got, one of our universities there, the University of Nebraska system has a school in Kearney. So there's a lot of university students. But really, I mean, at the end of the day, it's rural Nebraska. Biggest town is, 15,000 people. There's tractors on the road, there's farmers in the community, and that's the type of place that it is.
Before we get to your verdict, what kind of verdicts are we talking about out of this Buffalo County area? Is this plaintiff friendly, defense friendly? Are the numbers high, low?
Well, if you talk with an insurance lawyer, they're going to tell you that it's a low verdict county and can't win. I was hearing from my defense counsel, opposing counsel on this one, who lives further out and sees me as a city slicker, and so is trying to tell me I can't win in their district, right? That it's very, very defendant friendly. And there had just been a case just a few months ago where the person was drunk driving and was actually naked after they caused the crash. It was a defense verdict. Well, that has a lot to do with some of our laws not being very favorable in terms of if you admit liability, they're going to keep all that information from the jury. So the jury didn't know any of that. I don't like the idea that there's such a thing as a venue I can't win in. I believe we could communicate with people all over anywhere.
Said by a true trial attorney. I feel the same way. Venues don't scare us.
Right. That's what they say.
All right. So you're in a tough county. This is middle America. The income level, I'm sure, is not that great amongst this low population of people. This is not a county where you're expecting really high verdicts, and you'd be lucky to get a plaintiff verdict given the laws that kind of exist already. Fair enough?
That's what the defense says. Of course, I'm ever optimist, right? We're going to go and win. So that's what we say. That's what we do.
All right. So tell us a little bit about your client. Give me his age and who he is, and then start to walk us through what happened in this accident.
Rody, great guy, Cuban immigrant, black man, Spanish speaker, been married for 35 years, wonderful wife. He worked for 10 years at a packing plant in Lexington, Nebraska, which actually just happens to be in the news right now that Tyson is closing that specific plant. But he worked there for 10 years. just doing meat packing and stuff. And ultimately he was kind of like a lot of our immigrant workers, was used up and spit out, disabled. And by the time we got to trial, he's a naturalized citizen now, and is on federal disability because of his inability to work and the documented physical ailments that he had after working 10 years at the factory.
How old was he at the time?
Forgive me, but I'm going to say 65.
All right.
He's approximately 65 years old.
About
He's
65.
an older gentleman. He's more mature.
And was he on disability prior to this accident happening or as a result of?
Prior to this case, in terms of damages, which when we do show the video or when we talk about it, he had severe pre-existing conditions, and he had severe scoliosis, which is very visible on his x-rays. And really, and forgive me, I'm not trying to get too far in advance, but we did have his treating doctor testify. And I think it was one of the main things that was a part of his damages.
So we'll get to that. I just want to set the groundwork that we're talking about a 65-year-old pre-existing spinal condition, confirmed on disability way prior to this accident happening. So you are already dealing with a lot of what we'll call bad facts that you have to kind of get in front of, that the defense is at least going to abuse in their position as to why this accident either didn't cause the injuries being claimed or are not as a result of the accident itself.
Also, and I'm sure that this will burn a couple of insurance lawyers out there, but always concerned that they're going to try and inflame prejudice and bias, because now we've got an immigrant who is on federal disability and is going to be testifying through an interpreter. And, they may try and always salt in there this idea that, this person is taking up resources in our community that they really don't belong to them and shouldn't be. So, that as well, in terms of, just the pre-existing and the federal disability and such.
Without giving us too much, did they do that? Did they point to things like that in this trial?
In this case, I got to be honest with you, they didn't. I had two defense lawyers. The one who was definitely has done that to me in prior cases, and who I have to be, I would say, very cautious with. That particular lawyer, I'd be concerned would take the low road. She couldn't in this case because she represented the tractor driver, and that was one of the reasons I was able to neutralize her. The other lawyer for the trucking company was still an insurance lawyer who, you say whatever you want about him, but at least in this instance, he was pretty professional and he was decent, and he didn't go that way. So I'll give him that little bit of flowers there.
All right. So walk us through what happened here. How did the accident occur? When? Where? Tell us some details.
Oh man, it's been a few months since I did this trial, so I can't remember the exact date anymore, but it was summertime, and I think it was the fall. In Nebraska, we had a tractor that was on a 2-lane highway, meaning 2 lanes, and then there's a shoulder on each side, right? The tractor's oversized. The tractor for sure is got equipment on it that is bigger in terms of its dimensions than the 12-foot lane of traffic and the 10-foot shoulder. So you got 22 feet between the lane and the shoulder, right? And the tractor's bigger than that with all of its equipment. And so it's hanging over the center line a little bit, and it's driving down the highway. This is 100% legal in Nebraska, and actually this is really common. And during jury selection, people are like, yeah, tractors are a part of our community. What are we talking about? Everybody has experience driving behind tractors, and mostly it makes them frustrated because they're slow, all right? So people are used to this, but there's a tractor. It's going in one direction. My client is one of the vehicles that is trailing the tractor. And so he's behind it, and he has a video camera. And this is part of the facts. We actually have video of this crash happening. And so you can see it. But my client is just trailing a slow moving tractor that's a wide load and is crossing the lane. In the oncoming traffic is a propane truck. There's a company called Bosselman Propane. They distribute propane to all kinds of places in rural Nebraska, and they're in tanks. So this truck is loaded down with like 50 to 60 propane tanks. It's coming the opposite direction. Long story short, basically, well, the testimony eventually came out with him saying, I didn't see it, which is incredible when you have a big giant tractor with, flashing lights and big yellow fertilizer tanks on it. But says he didn't see it, didn't make any evasive maneuver whatsoever. Had a whole 10-foot shoulder that was empty and available to him, and just smashes into the tractor, sends propane tanks flying. directly at my client's vehicle. And, that's it. That's the explosion.
Let's pull up the video. Before you hit play, this trial, was it damages and liability or just damages? Did they concede liability between the two of them?
Well, I think that it was conceded that my client had 0% liability.
We have something called summary judgment, where you ask the court to immediately make that ruling so that by the time you get your damages verdict, you can actually collect interest from the two parties. Is there something like that in Nebraska or no?
No, of course we have summary judgment, and this would be a case where it was stipulated that my client had 0% liability, so we didn't need to do summary judgment. But there was definitely a dispute and a fight between the propane company and the tractor driver. And the propane company stated and argued throughout the trial that it was the tractor driver's fault.
Okay. All right. So for those listeners that are listening, either on Spotify or Apple Podcasts, obviously we also have this on YouTube. We're going to play the video of this accident there. So Ross, go ahead, hit play.
I think that's basically it. 15, 20 seconds of smashing and exploding.
Play it one more time.
And everybody, including the jury, loved to watch this video. We played it as often as we could at trial.
So, yeah, how do you go about playing it at trial? Are you showing it through your client's testimony, through their testimony of the drivers? How often did you play this thing?
We did get foundation stipulated that this is the video, right? By the time trial came, you'll always get opposing counsel that will say you can't show anything in opening that doesn't have foundation, hasn't been admitted to evidence. In this particular case, we had foundation here. And in Nebraska, I had a good faith reason to be telling the judge, hey, judge, foundation for this video is not in dispute. It's definitely going to be admitted. And an opening statement, I'm allowed to show the jury things that I think are going to be admitted into evidence. This is clearly it. And in this case, the judge did allow me to do that. So I played this in opening statement, and then I would show it to each witness where it was relevant. I tried not to obviously overdo it and be like annoying to the jury, but everybody wants to see this video over and over and over again. I didn't think that was an issue. And it makes it clear that I'm arguing for a completely innocent bystander in this case. So I showed it as often as I could, if I'm being honest.
So before we even play it, I mean, you can already tell that the tractor, he's not even within the lane. He's using a little bit of the shoulder on the right side. So it's not like this guy is completely out of place. He is where he's expected to be on this road. All right, so go ahead, play the video one more time. So we see your client there.
Yes.
And we see that, well, let me ask this question. Did the defense point to this video for the purpose of showing the jury, look, he doesn't look that hurt here?
Well, yeah. I mean, any defense lawyer is going to take this case and say that the damages are light. Our pretrial offer on this case was $25,000, and it was the Friday before trial. So, yeah, I mean, in this instance, you can see him. If you watch real closely, you can see where he like jerks to avoid, because it looks like there's actual propane tanks that are coming literally right at his head. It hit his windshield where his head would be, but not him, right? So you could see he makes like a fast jerking movement, and given his pre-existing conditions, we basically said that's what caused his injuries. And also when he got out of the vehicle, there was propane tanks on the ground, and if you're listening, you can't see it, but there's a lot of smoke around. It's gray around, there's smoke around. So when he got out of his vehicle, which he did immediately to keep himself safe, somebody could hit him from behind, right? He can't see what's going on, so he immediately gets out of his vehicle, and he actually tripped on propane tanks, fell, and that's where we argued that he ripped ligaments in his shoulder.
So what were the injuries for Mr. Pell?
We claimed aggravation of pre-existing scoliosis. We claimed he had a new shoulder injury because he had ligament damage in his shoulder that was revealed by an MRI. And then, his other damages, which It's not the traditional damages arguments that we make, but we said that, failure to pay his medical bills timely because he was on a fixed income, he was actually fired by his doctor who had treated him and his pre-existing scoliosis for 10 years. The jury didn't know the amount of money, but it was over a $300 bill. His treating doctor who'd been treating him for 10 years testified, and forgive me if I'm going too far in advance, but he testified that he had never been late on a bill at any time up to this case. And so we used the physical injuries, right? The shoulder, the aggravation of the pre-existing. And then we tried to really put on top of that, he had access to medical care that was destroyed. He lost his 10-year doctor. He had been sued and sent to collections and had his good name ruined. And he had been taking collections phone calls, collections letters, and collections lawsuits as a result of this. And all of that is how we framed his damages.
So David Ball talks quite a bit about that specific idea of the effect of isolating the patient from his doctors when they need it the most. Is that what you're referring to, what you kind of used in this trial?
100% David Ball. I use his damages on 3 for every trial, really. And I mean, the more trials I do, the less I have to, reflexively rely on it. But the fact is that it's a really good way to present a case. And 100%, I really think that that's the damages argument that resonated the most, was the idea that this is a guy who has a serious pre-existing medical condition. He has a doctor who has helped him regain function. That was part of the story, right? Between when he quit working at the plant and when this crash happened, he had been doing all kinds of physical therapy. He had been doing all kinds of things. And he had gone from not being able to walk around the block to being able to walk around a local lake with his wife before this crash. And that was a 10-year process that he had been doing with this one doctor. And that same doctor fired him because he was late on his medical bills. And those were medical bills that were related to this crash. And here he is, a 65-year-old man with a serious pre-existing condition. And now we got danger because he can't even get access to doctors. And I think that that really made a big impact on the jury.
So I want to turn a little bit back to the liability portion of it. And I kind of want you to walk us through the art of what it is that we do, the theater of trial, and the choices that you made here in order to get the result that you made. So how did you frame this in terms of how you would want this jury to decide in terms of who should be more at fault here, and what did you do?
Yeah, so I think that the main issue here is that it is a prominent local corporation versus a farmer, right? And I have been in Nebraska, I have been in rural places where I had to sue a farmer and it was tough, okay? The farmer is an archetype here in Nebraska that gets a lot of respect. And so in this instance, I've got a plaintiff who, is a great, but maybe has some stereotype boxes that could, maybe not resonate with this particular jury, which was an all white Nebraska rural jury. And so I've got my plaintiff who I don't want him to be too much the focus. I want it to be about this corporation and this farmer. I chose to kind of really, throw in with the farmer. Frankly, I think the truth is he wasn't liable. And I mentioned before that the farmer's lawyer, I have worked with her before, and she's certainly a very worthy opponent. If you ever oppose her in court, you don't want to take her lightly and you got to be on your toes. But in this instance, she doesn't argue sort of full throated the way that I do. And she kind of was wishy washy, trying to say that maybe we accept, 15% liability. So I just gave the farmer the defense that he really wanted, right? And started that way. Forgive me if that was too long of an answer, but in terms of like the actual witness presentation, we started with, there was one car in front of my client. It was a young woman, and she had the propane tanks come onto her, and she had her own PI claim and her own PI lawyer. She was our first witness. And so we used her, and she almost started crying on the stand. It was very dramatic for her.
Was this a joint trial with her case as well?
No, it was not. So she was just subpoenaed as a witness for our trial. She got to demonstrate the seriousness of it. She talked about how, hey, the farmer's doing everything pretty normal here, right? The farmer's going straight ahead. And so we start that way.
Your first witness is this fact witness.
Yes, absolutely.
Okay.
Who's another victim of this crash.
Okay.
Right. And we were kind of doing this idea of Joe Freed trying to go pretty fast too. So I didn't put her up there for very long. Maybe she testified for 20 minutes for me. Right. Got up there, got a little emotional, got down. Right. And clearly had no fault and clearly was injured. And so just this is an explosion. It's serious. Even though our client's injuries are not super obvious, us plaintiff lawyers, we've seen a lot of things. It's not my quadriplegic case, right? But just getting multiple people were affected, multiple people were injured. This is how it happened. And then we went through other witnesses, but we called the farmer. And of course, I did a direct examination that was really designed to be extremely generous to him. I think he was surprised, right? Because everybody always wondering what we're going to do, lawyers and everything would come at him. But this guy, so I just got out there all the basic facts. He's 68 years old. He had been working this particular field, right? If you're not a Nebraska person, this farmer owns this field. So he's gone on this route from where he was coming to where he was going. He had done that 32 years consecutively, once in the spring and once in the fall. So he's got 64 trips that he's been on this exact same route with this exact same equipment since 2011, right? And so, I ask him about those facts, get those facts, and then say, well, Mr. Farmer, how many people have driven by you going the opposite direction during that time? Oh, well, I don't know that I could count. No, you couldn't count because it's literally hundreds of people that have not rammed right into your tractor. So things like that, where we really set the facts to exonerate the farmer, right? And so we kind of put that all up front.
And you're doing that through witness testimony, not by reading depositions in. You're calling them in your case in chief.
Oh, yeah. I don't know. I mean, sometimes we all have to do a video deposition or something for an unavailable witness, but absolutely, if there's any young lawyers out there, subpoena people, get them in court, bro. Like, get live bodies on the witness stand and ask them questions and have them look at the jury. Sometimes it's a matter of money. So I'm not trying to throw any shade at any of our younger folks out there that maybe are like, man, getting that doctor into court is going to cost me, 20 grand or something. Get live bodies onto the witness stand if you can. It's always better, in my opinion.
Always. I agree with you. Okay. So you had the fact witness, you put on your farmer. Do you put on the propane driver?
Yeah. So then we put on the propane driver. And with the propane driver, he was honestly, he wasn't like that bad of a guy. And so I really wanted to be pretty gentle with him. But I also knew that he was kind of, I don't mean to be, he might, who knows, this might get on his lap somehow or something. I don't, kind of a dummy. All right. Like he wasn't really getting what we were saying. Right. Like, hey, bro, you had a whole shoulder there of 10 feet. All you had to do was merge slight left, and you're with the other hundreds or thousands of people that have driven by this tractor over the last 32 years that don't slam into it and cause a big explosion.
It's awareness of the road and awareness of the vehicles in front of you and the vehicle that you're driving.
Correct. He was youngish. He's 29 years old. We actually did a negligent hiring and supervision claim on this case. He had been fired previously for inattention, and he had been ordered to do a defensive driving course, which he never completed. And then he was rehired without having to redo that. All of that came in because of the negligent hiring and supervision. And so we just wanted to kind of just point out, like, this guy is not that attentive. And then, of course, we took out our CDL regulations, and they address all of these issues, including tractors, which are explicitly described as hazards that have a right to be on the road, and, that you need to be aware of these things. And so we did a little cross exam, the CDL book, right? Because he's a CDL driver. And he had obviously been coached. And some lawyers have experienced this, I don't know anything. I don't know anything. I don't know anything. Right. And so, as nicely, as gently as we could be like, you're the CDL driver, right? Yes. I want to give you the opportunity to answer this question correctly so that the jury can know that you know the answer. Do you want to try again? And he kept saying he didn't know. So then, of course, I would, impeach him with it and be like, well, it says that you're supposed to merge to the empty shoulder, right? It says that a tractor's a hazard, right? I just got those things out there, and I really wanted to be nice to him. You can't be mean to people in front of a jury.
I was just about to say, this is an art form that we talk about repeatedly, is how to cordially make the witness look terrible in front of your jury.
Right. And so I think we did that with the driver, where they could just see that he didn't know any of the CDL rules. He didn't know how to classify the tractor as a hazard and all of these things. And we kind of let that there. And so he was our second to last witness. And this was only a 4-day trial, Gennady. This was not a long trial, right? So he's our second to last witness. And at this point in the trial, the jury had seen the video, they had heard from the witnesses, they had heard from the farmer, now they've heard from the driver. And by this time, and including the driver's main testimony was that he didn't see it. And forgive me, when he said that, that was really extremely damaging to them because during the jury selection, I had kind of been like, well, hey, crashes happen and what's that? And there had been like a whole 5-minute conversation that was not planned about how annoying it is when people say that they didn't see something in a crash and that's their excuse. And I had a couple kind of blue collar guys that were like, man, that's just not cutting it. And it's just not cutting it when people say they didn't see it. And I knew I had that as deposition testimony from this guy. And that's what he said. And so I was kind of looking at those blue collar guys like, hey, I'm not trying to be too hard on him, but you hearing this? I didn't see it.
Those guys ended up being on your jury.
Oh, yeah. Yeah. I couldn't believe it that the defense lawyer didn't strike him, except for I have been through this process enough where a lot of insurance lawyers are really bad at striking people who have expressed things that are going to be very damaging. And I think it goes to this idea that they're not really open to what's going on. They're too much in their head, and they're still in this demographic thing where they're going to be taking people down for demographics, even though it doesn't help them at all. So they miss that. That has happened in quite a few trials that I've worked on.
Very common theme on this show with all the trials lawyers that I talk to. Defense attorneys are not listening to what these people are saying in the jury selection room. And let's hope it stays that way. It works to everyone's benefit that way.
And to that point, I don't know your listeners and how they think, and I'm sure there's some that are very experienced, and maybe there's some lawyers that are less experienced. And I think that, especially to those less experienced lawyers, you just got to get in there and you got to let them do that, right? You got to have the courage to just take it in there and understand they might be like a bad sports team that just commits penalty after penalty and error after error, and you didn't really have to do too much. They beat themselves if you can.
Any corporate reps involved in this case?
Yeah, so that's I'm going to say sort of the dramatic conclusion of the testimony that we put forward. We put forward their corporate rep, put him on the stand, and he was so in character. The other people, I'm sure, have heard or seen this, but he had to do this thing where he could not admit that there was any mistake at all. He had to take the position that this was totally okay. He did this thing, and we've heard it. I think of it on like when you see a corporate representative give a public statement after something bad, right? Where they just say, well, we see it all the time in public life. They just say what they wish were true, no matter how false it is, right? This was safe. This was good. We're a safe company. We're a good company. Safe, 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 safe. Nothing to see here, right? And this driver's a great kid and we're great people. And so, I got him in there, and there was this point in the direct where I'm like, he had the 10 feet to move into. Should he have done anything different? No, he shouldn't have done anything different. Okay. And then, of course, they do their cross. And on their cross, they go and they start talking about how they've won all these safety awards. They mentioned specifically that they had won a safety award in 2003, and this trial happened in 2025. Okay. And so they're safety awards and we're so safe and all of the things that they could think of about how the corporation is safe, including that this corporate safety guy, he does safety presentations and PowerPoint presentations. And I'm going around and talking with every different type of employee at our company about how to be safe, how to be safe, how to be safe. And then we get to the cross exam, and the point where I really started to feel that the jury was actually actively, some of these other lawyers who've had this, they're shaking their head, they're kind of like making these faces, and you're like, okay, you're really feeling like they're connecting with what you're saying. The culmination of it is I said, well, Mr. Safety Rep, you do these PowerPoint presentations you just described, right? Yeah. And you do those for the drivers, right? Yeah. How many drivers does Bosselman have? Oh, we got somewhere between, something like 65. I can't exactly remember the number he testified. I get 65 truck drivers. Okay. So I want you to imagine that you're giving one of these safety presentations. Okay, yeah. And you got a PowerPoint. Okay. And just like I've been showing in trial, the PowerPoint has this video that everybody here has watched. That's the subject of the presentation. Okay. Yeah. Okay. Are you going to tell all of your drivers to do exactly what the driver did in this case? Yes. Yeah, I'm going to do that.
Wow.
It was
Wow.
like too much almost, right? But you get these guys backed into these positions where now they've taken this counterfactual, everything is safe. There's no, he couldn't have done no safety maneuvers, nothing he could have done. Okay, so you're going to tell your propane drivers to ram into tractors on Nebraska highways. That's a really bad testimony. And like I said, the jury was, shaking their head and this, that, and the other. And I heard after the fact that the corporate rep was very upset about the outcome and how it went, and his responsibility for that. But really, it wasn't him. He had obviously been coached to hold the company line.
Did the defense come up with any points that you were surprised by or that you thought hearing it in the moment, like, okay, that may be a valid point that the jury may consider?
No, this lawyer that I posed for the company was a really, really experienced, 42 years practicing in Nebraska law. He's one of the deans of the insurance bar here. And so for me to get a good result against him has been really positive for me. But how would I describe it? Because I respect him and, whatever. But I feel like he was just totally tone deaf. He's older, right? And so I feel like maybe it was a little bit of a generational thing. And, we got all this energy out there, and I don't want to like in any way seem to be approving of it, but we got this I'm going to call it Luigi Mangione energy, right? Where there's just like people are just sick of the lying. People are just sick of the corporate doublespeak. People are sick of it, right? And forgive me, I'm 41. Maybe that makes me a millennial, and I'm sick of it. I'm so sick of corporations saying things that they wish were true when they know that they're not. And there's a lot on the line, actually, right? The lies matter. But I feel like this lawyer was just he was blind to it. He didn't see it. And so his delivery was very strong. He would say things very clearly. He would say things that, would make sense if the jury hadn't seen the video or heard the testimony, right? Sort of this argument style where you say it to manifest it as real. But in this instance, I told a couple friends and family, we got, football's big here in Nebraska. It was like somebody running down the field and taking a blindside hit. They didn't see it coming at all. Right. So he didn't brace for impact. He didn't make the arguments that I think that might have taken the edge or the bite off of my overall presentation. He, doubled down. And then, of course, at the end, it blew up in his face, just like these propane tanks did on my client.
It's always surprising to me when defendants don't come together. I think this case, we'll talk about the numbers in a moment. They really have the power to take the sting out if they just agree with each other. And I just had that on a case where I had two defendants. I couldn't wait to sit down and just have them point the finger at each other because it was a ludicrous accident. And the day after we selected a jury, right before opening, they said, you know what, we're going to concede to a split and let's just do damages only. And I was not happy about it. I got seven figures on it, but I could have gotten even more if I got the jury to really be infuriated with these lawyers, the positions that they're taking, and kind of what they're representing. It's really nice to be able to sit down and say, you guys go ahead and fight amongst each other and let me just make you both look like fools for these unreasonable positions. It's like every other lawyer says, you want to be the most credible attorney in the room. That's the key to victory.
This is a shining example of that. This trucking company could have struck a liability deal with the farmer. They were telling the jury 15%, which I don't want to get too far because we've got closing statements, right? But they were willing to accept some level of responsibility, but the strategic choice to use a sort of corporate doublespeak defense to attack a farmer and an innocent bystander really was not a strong strategic move in this case.
I want to move into damages and what he actually went through. What was his medical treatment? And how did you start to frame that in jury selection? Give me maybe if you use analogies or anything like that to kind of already start talking about the fact that we're talking about someone that's been injured before.
We tried to do what I'll call a judo law sort of thing, where we tried to take the pre existing condition, we owned it, and we tried to flip it back on them. And we said, that when a person has a pre-existing condition, they're more vulnerable, and the law says you have to take them as you find them. You don't get to explode propane tanks on somebody's face and say, well, you were hurt before, right? So that was the main thing that we tried to do. And then we only had one witness for medical. We only had one doctor. This was a very old man. He was like a 75-year-old doctor, general practitioner. And we had him come in and we had him lay the 10-year of treatment record that he had with our client in less than an hour. Okay. And the way we went through those records was to point out that when our client went to this doctor, he was, as I mentioned earlier, I must say, a used up part for these factories. And if you don't know how these factories work, people are the used up spare parts when they're done. So he comes out, he's all used up, he's hurt. And then you got this 10-year record where he's doing aquatic therapy, where the doctor is sending him to orthopedic doctors to get x-rays and just to do all these things. And little by little by little, he's gaining more function. In my opening statement, and then again in my closing statement, I used a cracked egg to illustrate this. And I had a PowerPoint slide where I had the egg and it had a crack. And then the next one, the crack gets a little bit bigger. And then the next one, the crack gets a little bit bigger. And then the next one, a piece of the egg is like, the shell of the egg is like, now it's like falling down and it's out. And then I had it where I put a little Band-Aid over it and put all those cracks back together. And that was the last egg. And that was sort of symbolic for him working with this doctor and feeling a little bit better. Then I put a picture of the big giant explosion with propane tanks coming at his face. And then I had a picture of the egg with all of its, shell pieces down on the ground, right? Just kind of pointing out that, here he was, of course he was injured. He had a pre-existing condition. He's getting better. And then something bad happens. And now he's worse than when he started after all this effort that he put in and all this time that he put in, and gee whiz, how horrible is that? And so that's the way that we really framed the pre-existing condition to try and bring it back into a strength for us.
What was the defense position with respect to the shoulder, if any? That was a new injury, you said. Did they try and dispute all of it was unrelated?
They did, and this is where I mentioned before, and I don't mean to lay it on too thick for this opposing counsel. I've worked with her multiple times, but she's the one to be really concerned about who will say things that don't match anything and that are make a plaintiff lawyer feel like, man, upset about it. Okay, like she won't respect what I would think are professionalism in terms of argument. But in this case, I froze her because she represented the tractor driver and she couldn't come too hard at me. But even so, she tried to. And what she tried to say about the shoulder was that he was lying about having fallen down after he got out of his car and that he hadn't actually hurt his shoulder. And the way she presented it, how it was hidden inside of long arguments, she didn't use any PowerPoint, she didn't use any pictures. This is one of these classic, defense lawyers who stands up with some papers and kind of nervously reads them and too fast. And I'm not trying to be hard on her or whatever, but it's kind of buried the lead, I would say. And also, it didn't match the evidence. I had kind of anticipated it, and I had a picture from the fire department where there was a propane tank. You got your driver door and you got your back seat passenger door, right, on the driver's side. And there was a propane tank right there in the concrete. And so I kind of knew she was going to say something like that. And so I had that ready for my closing statement. Be like, look at that. That's right there. That was taken by the fire department. That wasn't taken by our guy. You saw the video. There's all this smoke. There's no way he would have been able to see that. It makes sense that he would have fallen and hurt his shoulder. So that was, I would say, we all have to deal with that with lawyers and what they're going to say and what kind of bologna sandwich or below standard or whatever you want to call it, defenses they're going to come up with. That was what they tried to do on this one.
Did they bring in experts?
No defense experts. I think they just really thought that the damages on this case were so light, so weak, that they were just not worried about it, if that makes sense.
You did something really slick and beautiful in your closing with one of the images that you put up when it came to trying to show the corporate position. Can you pull up one of your closing slides to show us what you did and just kind of walk us through the idea behind this and how often you do this?
I'm sharing right now my closing statement PowerPoint presentation. And so to your question, how often do I do stuff like this? I do this stuff every trial. It just depends on what the trial provides, right? So in this case, I've used the phrase double speak. I don't know if everybody kind of knows what I mean. 1984, George Orwell, where you say it's one thing, but it's obviously the opposite. And that was the testimony of the corporate rep in this case, just how this was safe, this was safe, this was safe. And he kept saying they hadn't had any safety events, and that included during the time period of this. So we put up our closing statement and we just said, again, keeping the focus, Bosselman's corporate decisions, bring the hazmat truck to the tractor. We put up this still frame. It's what I'm going to say is the most impactful of the still frames, where you can see, a dozen plus propane tanks. They're coming directly at our guy's car. You can see the smoke coming. And, then I go on Chat GPT and I say, well, they were talking about how they won this Gold Star Safety Award, right? In 2003. Boom, Gold Star Safety. This is what they want. And so Chat GPT spits out, a generic Gold Star Safety logo.
It looks so good. Folks, if you're just listening, please just go and look at this. It looks so official. And this is such a good example of how you can use AI, ChatGPT, all these programs to really strengthen your position. I mean, all this is a simple, really well put together slide that speaks volumes. I mean, it's just a still image from the dash cam, and you have your Gold Star Safety like it's an official, it looks like an official image here. And then on the left side, you have another image that's created by AI that says specifically Bosselman approved, like those approved stamps that you put on documents. So strong.
Yeah, they had kept talking about his spotless driving record too, and he said it in opening statement, and I wrote it down. It probably felt like hot lead when I was talking about it. Based on his rebuttal closing statement, he certainly noticed it, the opposing counsel. But this was just their doublespeak, and so if this is safety, then let's make sure the jury knows what they think safety is.
So what did the jury find when it came to liability with respect to the propane driver and the tractor driver?
But during closing statement, I had mentioned that the tractor driver had the most cunning defense lawyer, right? And so cunning defense lawyers don't usually, they may be difficult to work with. They may be danger to beat you in your case. They may be a good, lawyer from the point of view of an insurance company or whatever, but they just don't really know how to argue in a way that speaks to people's heart and soul, in my opinion. And I would like to believe that that's what I'm trying to do, speaking about truth, speaking about justice, speaking about righteousness, right? And every once in a while, I'm successful in creating that sort of energy in the courtroom. And so during the closing statement, I really tried to make a little bit of a, we're showmen, we're storytellers, right? But I'm trying to bring this out, right? I'm in my middle of my closing statement. I turn around, I'm looking at the jury, right? And I'm talking about liability. And I turn around and I look at the tractor driver and I say, I'm really sorry that I had to sue you. If it was just up to me, you wouldn't even be here. But I knew that I had to sue you because they were going to blame you. And then I start kind of waxing poetically. And the guy literally in front of the jury in the whole room, he's 68-year-old Nebraska farmer man. Okay. And he starts tearing up and welling in the courtroom because his own lawyer, her cunning attitude, he never felt like he was getting a full-throated defense. And actually, I've worked with this lawyer before. I've been talking about her. You could sense that I'm not personal friends with her. I'm trying to be respectful to her. I think it kind of burned her a little bit because afterwards, the farmer comes out and shakes my hand and tells me he wishes I was his lawyer.
What a compliment.
All right. I told the jury 0% liability for the tractor driver. 0. Don't even think about it. He didn't do anything wrong. He's as much of a victim as anybody, and he's a victim to corporate lies. And I did use the word lies in my closing statement. It did get a reaction from my opposing counsel, which we could discuss. But I wanted it to be clear that this corporate lying and corporate denials isn't just impacting my client, it's impacting everybody. And lies do have consequences. And, I think, like I said, he really appreciated that. In the end, the verdict was 0% liability for the tractor driver. And again, his own lawyer in her closing statement, which had a totally different energy, said that maybe we accept up to 15% liability, right? And so the jury was like, obviously, like, she didn't have a lot of credibility with them, because of her, how wishy-washy. Sometimes lawyers say that I see my point of view too strongly and speak it too clearly. I'm not seeing all the angles. I'm like, nah, man, I'm giving you a coherent vision for reality, and I'm going to speak it out, and I'm going to speak it out with clarity. I'm not going to kind of go halfway.
That 25,000 pretrial offer, was that a global offer from both of them?
Yes, it was.
Oh,
Yeah.
so they were thrilled. The farmer's insurance company was thrilled to get 0%.
Farmer end up paying. Actually, you know what? Forgive me. I got to take that back. The farmer did make offers to settle so they could be pulled out of the case that were for something else. But I was like, I can't do that. I can't let you out. If there's no settlement, you have to be there. I'm not going to argue that you're at fault, but if you want to pay me some money in advance of trial and still be at trial defending your case, then I'll let you do that, and you can escape any potential, joint and several liability. But you have to be there. They actually offered more than the Bosselman people, but I didn't take it. And then the $25,000 offer the Friday before was from Bosselman.
What was the verdict?
Verdict was for 500 and gosh, I'd have to see the form, 512 and change, something like that.
512,000. Just to make it clear, 25,000 pretrial offer, 512,000 verdict for a immigrant, Spanish, Black, pre-existing injury plaintiff, no surgery, in the middle of nowhere, farmer country, Nebraska. Unbelievable. Were there any other aha moments that you felt were really critical in this case on the damages side?
Maybe it's not so much the damages side, but it kind of goes to what you're talking about, right? We had this, Cuban, Afro Cuban, Black guy, Spanish speaking immigrant, and we got an all white jury. And people ask me, how do I deal with that? I'm here in Nebraska. This happens all the time. I speak Spanish. I've represented undocumented clients and won jury verdicts for undocumented clients in Nebraska, telling the jury that they're undocumented. And so I'm kind of getting a little bit better at how to speak about this with the juries over the years. And with this jury, I think there was a moment, where I said, hey, when we have a client like this, and you're an all-white jury, I can see it on their face, like, well, what'd you just say? You just brought up race, right? Okay, yeah. We're here. We're in rural Nebraska. We got an all-white jury. I got a Black client.
Where are you saying this? In jury selection, opening, closing?
This is closing statement.
Okay, go ahead.
You're an all-white jury. I got a Black client. Do you think that he had fear to bring this case forward? I'm going to tell you he did have fear. He had fear that he wouldn't be seen, that he wouldn't be heard, that he wouldn't be able to get justice in a Nebraska courtroom. And I told him, even if you have that fear, we can't be the ones who make racism real in our office by saying that we don't trust our neighbors enough to give them the opportunity to do the right thing. And I know these people. These are my people, okay? Nebraska people are my people. And Nebraska people were not raised to be discriminatory, to send you home with nothing. They'll do the right thing, but you have to give them the opportunity. And I'm looking at the jury and I say, now listen, we've taken our action. It's not just words. I'm not telling you pretty flowery words about doing the right thing. I'm telling you that we have taken the action. We have put our heart in your hands because we trust you to do the right thing. So I'm not asking you to do anything other than to take your oath and be serious about it. Deliver that blind justice for us. Deliver for us a justice that is free of prejudice and free of bias that we can be proud of in Nebraska. And they, of course, shaking their heads. And I know that resonates with people. I know that people want the opportunity to do the right thing, and they want to deliver a justice that we can be proud of. And so when they understand that do we have fear? Heck yeah, we got fear. But we're going to give you the opportunity to do the right thing. And just as a little side point for the lawyers out there, you get a case like this and you got the fear and you're wondering if you can win. And you're thinking, man, I'm going to sit this one out on the sideline. This one's good for settling. And I want you to remember, every single one of us probably that's plaintiff lawyers has read To Kill a Mockingbird, right? Atticus Finch and all these little kids all over the country named Atticus. Atticus Finch lost that trial. That was a verdict against his client. His client was convicted of murder when he wasn't or rape, when that wasn't true. And he was the hero. I would encourage every single lawyer out there who confronts this issue. If I can win for Black, Spanish-speaking Cubans in Buffalo County and undocumented immigrants all over Nebraska and Iowa. You can win for your clients anywhere. I'm telling you. But you got to get off the sideline. You got to believe in it. And if what I just said can give you a little bit of a paradigm, you tell that jury that the reason you're there is because you believe in them.
Ross, you are a legend. This is why I brought you onto this show. I can tell you are just so good at representing and caring and just, we'll use the term, giving a fuck about your client and making sure that justice always wins. Well done. That was a beautiful gem that everyone should use, giving jurors, making them feel like the power is in their hands and that power can only be used for good, and just giving them no other option. That was really well done. I want to thank you for being on the show, for sharing this story for Mr. Pell, for Mr. Pell's family, and for all the clients that you represent, for giving us a sneak peek into what could happen in the middle of nowhere in Nebraska, and for continuing to represent all the clients that you do. I really appreciate the time that you gave us and the gems that you just gave us.
All right, man. Well, thank you for the opportunity. And as always, I tell my clients it's a real pleasure to be able to represent them. When they give me the opportunity to represent them, that means that I don't have to sell out and represent corporations and insurance companies and bad actors. So, I think that every single one of us should be grateful for the opportunity to represent real people, real cases, righteous causes. And certainly, I'm very grateful for that opportunity.
Folks, this is a reminder that juries don't just decide facts, they decide values. They protected a farmer here. They protected an immigrant. They rejected corporate doublespeak. And they didn't need a burning bush to recognize when someone was calling an explosion safe. For our listeners, that's it for this episode of Trial Bible. Use your exhibits, know your jurors, know your defense counsel. And if a corporation tells you a fireball is safe, make sure the jury reads that verse twice. We'll see you next time. That's a wrap for this episode of The Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.